Yes, Fantastic Dean.
Thank you. Lords, there was just one final point that I inadvertently missed when pointing you to the portions of Justice Winder's ruling which showed an intention on the part of the defendant to conceal. The last one was at paragraph 44 of his ruling, which is at page 457 of the record. And I started, Lady Wilson submitted that mere knowledge is not sufficient, and that in order to vitiate the sale, the court must be satisfied that the appellant was a participant in the fraud against the respondents. I do not agree. In my view, knowledge is sufficient as it negates the assertion that the appellant was an innocent purchaser. It should also be noted that the learned judge did not purport to vitiate the sale, but rather determined that the appellant holds the property jointly for herself and for the estate of Charles Sr. as trustee. She therefore holds Charles Sr.'s undivided half interest in trust as tenants in common with her own beneficial interest. My Lord, that was the Court of Appeal, I'm sorry, my Lords.
Yes.
That I pointed you to, pardon me.
That's not dealing with the deliberate concealment point, though, is it? It was in the context of the argument about the sale, the first two grounds of appeal. Whether it was a valid sale.
Yes, my Lord.
I don't think there's any challenge to the judge at this stage to the judge's finding that Denise was not a bona fide purchaser for value without notice.
Okay, I was actually going to cover that. But in other words, if that is an accepted fact, I won't. But I did intend.
Well, Mr. Rowe hasn't challenged that in his grounds of appeal, on the ones he's pursuing anyway.
Yes.
He's taking a point about deliberate concealment and a point about the interest of whether the estate had an interest in the property at the time of the sale.
My Lord, what I would say.
I don't think he could. There are concurrent findings about that Denise was not a bona fide purchaser for value without notice.
Yes, my Lord, what I would say then is just quickly to that is that under the Administration of Estates Act, it's a two-limb test. The second part is that the purchaser, in my terms, would have to be a bona fide purchaser for value. And so if that part fails, then necessarily title could not pass.
Well, the argument against you is that Charles Senior's estate did not have an interest at the time of the sale. That's the argument Mr. Rowe's making.
Right.
So there was nothing to. I mean, if there was an interest, then it wouldn't have been extinguished by the sale because Denise was not a bona fide purchaser for value. But Mr. Rowe is arguing that the executor had the entire interest, legal and beneficial, in the property, and so the fact that Denise was not a bona fide purchaser for value doesn't matter because there was no interest to preserve.
Yes, my Lord. So then, in that case, if it's accepted that she wasn't a bona fide purchaser for value, then of course we rely on some of what I've already began to cover about his implied assent and the fact that there was no debts to the estate, etc. I think I already at the end indicated that title would have passed because Edison became a trustee of Charles Sr.'s assets, well, Charles Sr.'s interests, by reason of the fact that there was nothing left to be done on the administration of the estate of Pearl L.
That's the argument you make at paragraph 76 of your case that we were looking at this morning.
Onwards, yes.
Yes.
So I suppose if your lordships are, if we manage to convince you of that point, then you're saying the rest will follow. Thank you, my lord.
Well, subject to the limitation argument.
Yes, yes, of course.
Which you've already addressed.
Yes, of course.
Although you haven't addressed the reasonable diligence point yet, I think.
No, I haven't. And before I go over to reasonable diligence, my lord, there is one other sort of limitation point that they have circled back, which is the alleged possession by Denise, by the appellant. And we haven't yet addressed that either.
No.
And what we say is that that argument also has to fail. And it has to fail because the appellant never really showed in our submission that she was demonstrably in occupation of the property, and that there was really nothing to put the respondents on notice that she was in occupation. So in other words, just to expand that.
But you can't dispute that she was in possession of the property from the time she bought it, can you?
Well, yeah, certainly from the time she bought it, the conveyance is dated in May 8th.
Yes.
And it was filed in November.
Well,
we, of course, go with the November date as to notice to the world, because we would
well, we're not talking about notice, we're talking about possession.
Yeah. Well, when she went into possession, she can only, on our case, have gone into possession of Edison's interest.
Well, not from the time that the property was sold to her.
Yes, but we would say that in terms of her being in possession, there would have been no way for anyone in the world, or most particularly, and we have to look at the particular facts in this matter, most particularly our clients, the respondents, to know that she was purporting to be adversely possessing.
But that knowledge isn't the point. For adverse possession, all you have to do is show that you were in possession of the property, and that to the exclusion of the rightful owner. And I thought there was plenty of evidence that she was in possession of the property from at least the May, when the sale was completed, if not earlier, which wasn't actually controverted at the trial, I think. No,
it's the fact that she went into occupation of it absolutely was not controverted. She went in, she did some repairs.
Yes.
She lived there for however many years it was. She moved out, she put in some tenants or...
Yes, so that's the basis of the adverse possession argument.
Yeah. And our position on that, well, it's twofold. One is that in terms of her adverse possession, we only would look at that by way of the concealment that we've already alleged, and that the expansion of the limitation period in order to defend it, and the filing of the action in time. That would be how we would respond to the allegation of alleged adverse possession outside of the other submissions we were seeking to make. We would also indicate, my lords, that the 2015 action, which my learned friend would have taken you through as he was going through the pleadings this morning, that would have acted to stop her adverse possession. That would be, pardon me, my lords.
That's the June 2015, but it won't make any difference. The difference between June and August doesn't actually help you, does it? It doesn't get you over the line. Between whether you take time running from the action that your clients brought in June 2015 or their counterclaim to her action in August 2015, they're both the wrong side of May, when the 12 years had come to an end. So you have to rely on an extension of the period.
Yeah. Yes, my lord. So... yes, our response to the adverse possession is as I outlined just now. There was another point that had been raised, and again, I don't know that my learned friend dealt with it, and if he didn't, It relates to Section 41 of the Limitation Act, Section 41 sub 5. And I really just wanted to...
What page number is that on?
I'm looking at the Court of Appeals ruling, page 461. And it was really just to take you to Justice Evans' comments in this regard.
This is a provision that protects
because if this has to go to the bona
purchases.
fide purchase price, then let me just, one moment, please. Yeah. And my Lord, based on our saying saying that they're just relying on the fact that they had the right to sell the entirety, I won't take you to that section, as that relates to whether or not Denise was an innocent purchaser or not.
Yeah.
So. My Lord, we do say that there was one more finding by Justice Winder that is of assistance with respect to the Limitation Act and the extension thereof, and therefore the filing in time. And that would have been Justice Winder's interpretation of Section 36 sub 1 of the Limitation Act, which we say would have been correctly decided by him. We deal with that at paragraphs 38 to 40 of our case stated, which is at pages 401 to 402 of the bundle. And if I were to paraphrase it, my Lord, Justice Winder interprets Section 36(1) of the Limitation Act as settling that the limitation period cannot begin to run until the person under a disability, in this case disability being a minority, overcomes their disability, in this case would have turned 18 years old. And we quote from that ruling at paragraph 17.
But this can't help you, because all it shows is that for 6 years after you've ceased to be under a disability, you must be entitled to bring an action. But that's not going to help you here, is it? Because the action was brought long after 6 years after both respondents ceased to be under a disability.
You don't add 6 years onto the 12 years.
No, you don't. It's just whichever is the greater. You can either rely on the ordinary limitation period or 6 years from when you cease to be under a disability, whichever is more favourable to you. That's what it says.
I think that the way that Winder interpreted it, and this would have been, in his interlocutory ruling, was that he said the relevant limitation period starts from that. So he said it's not 6 years, because that would have had the impact of reducing the 12 years adverse.
They were making...
The argument against you at that stage was that the relevant period was 6 years and you were out of time.
Yes.
And he said no, the relevant period is a 12-year period at the stage of a strikeout.
What's the limitation period if there is a constructive trust and your client is trying to enforce that trust?
A constructive trust?
Well, if Denise holds the property as
there is
a
no
trustee,
limitation period based on what was shared by your lordships today.
Yes.
Okay.
There would be no limitation period for them to recover the property.
And how does that interact with Section 23 then?
Section 23 of the
Which is, yes.
Pardon me a minute.
This would be by virtue of Section 33 of the Act, of it. No period of limitation shall apply to an action by a beneficiary under a trust.
Yes, my lords. The section 33 that you shared with us this morning definitely said there would be no limitation period if they're recovering the assets of a trust.
And even if that includes land?
Yes, I think it specifically mentioned land. So that would mean, my lords, that, well, it means that the respondents are entitled to trace, or not trace, but to go after the assets held in the trust and to hopefully secure them. So we would say on that basis that Justice Winder did in fact find that Denise holds the 1/2 interest in the property as a constructive trustee on behalf of the respondents. And pursuant to section 33 of the Act, there would be no limitation period, and therefore the action would have been commenced properly, and the ruling by the lower courts should be upheld in its entirety as it relates to how to deal with the property. You know, but they're still saying no, just that. Pardon me, my lords. So, my lords, with that, I think I should turn just briefly to the second half of the matter, which deals with the merits. I've touched upon some of them. Perhaps the
Are you going to deal with reasonable diligence, or have you decided not to?
No, of course, my lord, reasonable diligence. Our submission, of course, is that the respondents, first and foremost, that as minors, when this deed would have first been recorded, it would not have been reasonable to expect that they could have determined or made any finding with respect to the transfer of the property. And further, that as soon as she pretty much attained the majority, Pearl began seeking to assert her rights and to chase what has happened here. And she did eventually find out through her searches of the registry that, in fact, her father had an interest in the property. I go further to state that in any event, the right, although they say that the estate of Pearl L was, the probate was granted in 1987, I think it was off the top of my head, that's irrelevant, quite frankly, because Charles Sr. the children, did not have any interest in the Pearl L estate. So there was nothing for them to look for. There was nothing for anybody on their behalf to look for. It was not until Charles Sr. passed away that the question even becomes relevant. So the date of the probate of Pearl L's estate is irrelevant with respect to the reasonable diligence question. Having searched for it and found it, we would then also say that at that point, you can only, with respect to, we still maintain with respect to the occupation, that the real notice is as Justice Winder found, which was the date of the recording of the deed in November of 2003.
Well, why is that notice of the interest of Charles Sr. in the property? It's notice of the sale, but that's not what we're concerned with here. With the relevant fact, as you put it, is the interest of Charles Sr.
Correct.
So why does it matter when the sale became searchable or not?
No, I withdraw that, obviously. It's not relevant to when his interest arose. But in terms of when the children could have found out, we would say that they did exercise all reasonable diligence.
Was there any argument about this at the trial, or was it just nothing said about this point?
My Lord, I honestly don't recall it being fleshed out, at least to the level that we're doing here. I do recall the point which I was muddling it with, about when was it reasonable to expect them to find out about the recording of the deed. But in terms of the ownership, like when Charles's interest came into existence, I do not recall that being fleshed out fully.
Yep.
Well,
Do you recall it being fleshed out in any way? My associate is saying to me that he only recalls when Pearl gave evidence. She spoke to when she became aware of her father having an interest, but as to it being argued in any material way, we don't recall that. So, Lords, with that, the crux of our arguments as it relates to the merits, is as we've already hit upon in our discussions. Pardon me, the Lords. Lords, just to close out on the reasonable diligence, the closest that we could find that comes to any reference to it, and it's not a direct reference really, is at 468, paragraph 70 of Justice Evans' ruling, where he says, "It is clear that the judge's reference to Section 30 of the Limitation Act is an alternate position to his primary finding that the operative period commenced in November 2003 and expired November 2015. I am in agreement with the finding of the learned judge that on the evidence, the earliest that the respondents would have been aware that the appellant..." No, this is still dealing with... No, this doesn't deal with the question that you asked, which is when did they become aware of his having the interest? Okay. Well, Lords, I take it, although we've touched upon it, the arguments that we've all been circling around regarding the fact that Edison as personal representative converted into a trustee, they arise out of Section 3 sub 2 of the Administration of Estates Act 2002, which carried over into our Section 59 sub 2 of the Probate and Administration of Estates Act 2011. Because I want to pause there for a moment, because as a part of that section, it also expressly says that a personal representative shall become a trustee, and I'll read the section in a moment. And it's been suggested by my learned friend that that is in some way perhaps not intended because of the UK statutes. But I'd just like to point to the fact that...
You couldn't refer me to the page number for the section. What page? What page?
Yeah.
Are we on?
Pardon me, my lords.
$14.94.
That's right.
Section 3 of the Administration of Trustee Act, 1494, as my learned friend provided. I read it. Real estate to which a deceased person was entitled for an interest, not ceasing on his death, shall on his death and notwithstanding any testamentary disposition thereof, devolve on the personal representative of the deceased. Understood. Subsection 2. The personal representative shall be the representative of the deceased in regard to his real estate to which he was entitled for an interest, not ceasing on his death, as well as in regard to his personal estate, and shall hold the estate as trustee for the persons by law entitled thereto. And that carries over into the 2011 Act, verbatim as it is there. And we say the fact that our draftsman in the Bahamas bought that over 9 years later is a clear indication that it absolutely is intended to mean what it says.
Well, what does it say? That's a difficult thing, isn't it?
What does?
When you say it's intended to mean what it says.
It says, in particular, subsection 2, that the personal representative shall hold the estate as trustee for the person.
I know, if you just focus on that bit, but what does the earlier bit mean?
The earlier bit, initially, the real estate. So I don't want to just read it back to you again. But initially, the real estate moves to, or the personal representative holds it as a personal representative for the estate. So the estate of the deceased moves upon death to the personal representative.
So in this case, the testatrix owned the property in fee simple, and the fee simple title then devolved on Edison.
Yes.
Okay.
Right? And then it moves on to say, I submit, in subparagraph 2, that the personal representative holds that estate as trustee for the persons by law entitled thereto.
And who are the persons in law entitled thereto?
The persons in law entitled thereto, my lord, we would say, it actually shifts. So once the estate has been fully administered, in particular what I mean by that is that all of the debts of the estate have been realized, then at that point the persons entitled to become the beneficiaries of the estate. And in this case there was a specific devise. So the person entitled, or the persons entitled to, in this particular instance, became Edison and Charles in equal portions.
Well, then nothing turns on this provision. You accept the principle, do you, that to begin with, let's say, well, there are still debts to deal with, the executor, there's no distinction between the legal and equitable interests. The executor holds all interest in the property that the deceased had.
Yes.
Well, I'm just wondering, just been looking at the terms of this statutory provision. We're told in subsection 2, the personal representative shall be the representative of the deceased, and there's a definition clause earlier on which tells us that representation means the probate of a will and administration. Okay. And shall hold the estate as trustee. So this seems to be general. It's not saying that once the estate has been administered, the personal representative holds the estate as trustee. But it's saying in general terms, the personal representative
Absolutely.
Shall be the representative and shall hold the estate. So in other words, you do both things at once. As trustee for the persons by law entitled thereto. Well, who are the persons by law entitled to the estate? Well, I suppose the first the first claims on it would be creditors.
The debtors, the creditors.
And then once the creditors have been paid, then various beneficiaries.
Yes, my lord, that is our position.
And the first category would be any specific bequests. And once you've paid off the creditors, and if there are no outstanding specific legacies, then the residue of the estate is presumably held in trust for the people entitled under the law to share in the residue.
Yes, my lord, that's exactly our position. And we say that is expressed by statute, despite what my learned friend would like it to say, as he would say. That is expressed by our statute.
We have suggested it's maybe not quite the same as the common law position in England.
So was there ever any similar provision to this in England, or has there never been one in England?
I believe that there was one, and I believe we actually referred to it in our submission. I honestly don't remember it off the top of my head. But it's...
Yes, because we're just wondering how to square this with the statements we've seen in some of the English authorities to the effect that the executor only holds as trustee once the estate has been administered. But it may be, so we're wondering if this is a statutory provision which is different from English common law, or if there was something similar in England after all.
Based on our research, ours is an equivalent of Section 2(1) of the English Land Transfer Act of 1897.
Section what, sorry?
Section 2(1) of the English Land Transfer Act of 1897. And it's provided in Volume 1, Tab 7, at page 51542.
I think according to the appellant's case, there are conflicting authorities in Ireland and Northern Ireland on this point.
Yes. And so what we have, in fact, I believe my learned friends would have presented a case which interprets it one way, and we would have presented a case out of Canada, which has a similar provision, and interprets it in the manner that we've been discussing here today, which interprets it as once the debts of the estate have been settled, then the personal representative holds as trustee. The second, I will take you to that case in a moment, but just before I do that, in summary and overarching, the second thing that we would say is that the other way that a personal representative or executor becomes a trustee is by virtue of specific devises. So again, if the debts have been settled, they become a trustee of the specific devises in a will.
So whereabouts at page 1542 do we find the exact equivalent provision? I see it's section 2, subsection 1.
Yes. It's quite interesting that it uses the phrase beneficially entitled virtue.
And would a creditor be beneficially entitled virtue?
No, he wouldn't be, would he? You just have a claim.
Yeah.
Lord, I'm sorry, but I know that's 1542, but my page is actually not numbered. But it says chapter 65.
Yes, we have it in front of us.
Okay.
Thank you. We see the provision you're referring to.
Yeah. And have you looked to see whether any old English authorities interpreted that?
No. I don't have any Old English authorities.
No.
You look, we did look, but I don't have any. The closest authority that we found was the Canadian one,
Right.
Which I was shocked when Mr. Smith told me how he did it, quite frankly. You know,
So whereabouts is the Canadian authority? Sorry.
that's the Appellant decision.
Where is it?
That is page 1695. This is yours. Sorry, my lords, I'm going through. That's not the one. Sorry, my lords, the case which I was referring to, that's not the one, is at 1660, George Attenborough. And it's actually a House of Lords decision from 1913. Pardon me, my lords. And it was a decision by Viscount Haldane. And at page, it's a short decision, my lords, but I'll just take you to a couple of relevant citations in it. At page 1665, just above the break for page 84, about midway down the paragraph, "Now, my lords," he continues, "I am of the opinion that the true inference to be drawn from the facts is that the executors considered that they had done all that was due from them as executors." I should say that in this case as well, the formal deed of assent had not issued. And then I'm jumping to the bottom. "My lords, if this be so, this appeal must be disposed of on the footing that, in point of fact, the executors assented at a very early date to the dispositions of the will taking effect. It follows that under these dispositions, the residuary estate, including the chattels in question, became vested in the trustees as trustees."
There's not a case on the equivalent statutory provision that, on the statutory provision you just showed us, is it?
No, it's a case.
And that's what I thought you were
Sorry.
going to when you went to a Canadian case. You said that there was a Canadian case on an equivalent Canadian provision, which possibly was the one that you were taking us to. Now you've jumped off onto a different point.
I'm sorry, my lord.
I mean, I think on 1697 they do seem to be talking about, I don't know whether it's in civil terms or it isn't, but in the middle of that page they quote, the personal representative of the deceased person holds the real property as trustee for the persons beneficially entitled thereto.
Yeah.
Is that's what you're relying on as a Canadian authority, is it, on a similar
Yes,
provision?
yes, my lord. And he goes on, sorry, just below that, the other highlighted portion, Mr. Justice Clemens stated, in my opinion, the provisions come into operation upon the death of the intestate and effect an indefeasible vesting in the beneficiary of the interest provided to which the administrators must give effect, albeit subject to the dealings with the vested interest by the beneficiary. In this view, the vesting of the interest is not dependent upon an order of the court granting administration of the intestate's estate. It takes place by force of imperative statutory provision operating at the moment of death of an intestate. So, my lord, we take, as I said, we take the position that Edison held as trustee, and as trustee, he could not unilaterally or in and of himself decide to sell the interests of Charles. Sorry, my lord, some of this I've already addressed you on. With respect to implied assent, that what we have indicated there is that the conduct of all of the parties in this matter make it clear that they all view Charles as not just having an interest in the property, but as owning the property. This can be found by virtue of the fact that when they being Barbara Barnes on behalf of Edison sought to probate Charles's estate, when they put in the documents for probate, they indicated that the asset, or Charles's asset, was in fact his half interest in the property. That was clearly, and that was ahead of Pearl L's estate being probated. So in their minds, they clearly accepted that Charles was already vested with a half interest in the property when they were seeking to probate the estate. It was only when their attempt to do that failed, because they couldn't clear off the children, that they circled back and decided to sell direct out of the estate of Pearl L. So there was also, in addition to that, Charles's continued occupation of the home, not just living there, but repairing, making all the necessary work. I did hear you say there was money going to Edison, or there was evidence of that, but there's no evidence as to what the monies were for. But the evidence, certainly from the children, was, and others I think, was that he did everything in the house. For all extents and purposes, he reacted like the full owner of the house. And so much so, quite frankly, that it were part, you know, were he alive, it would have been possible for him to even try to say that he had gained a full interest in the house as a result of how he was permitted to utilize the house for his benefit, his sole benefit. But everyone, no one interfered with his dealings with the home. And we say that is another indication that they accepted his ownership of the home. And it is, we have provided your lordship with an extract from Halsbury's at paragraph 84, page 1. I'm reading from my submissions rather than from the text itself.
Where's the text?
It's at 1417.
I know, but can you give us the actual, where we find the...
It's at volume 2, page 2352. And there it reads, an assent to the vesting of personal estate or of an equitable interest in the real estate may be expressed or implied. It need not be in writing, nor need it be given in any particular form. Informal expressions, if sufficiently clear to indicate intention, may amount to an assent. The assent may also be implied from the executor's conduct. And then we jump down to the penultimate paragraph. In the case of dispute, the question whether there has been an assent or not is generally one of fact, but an expression which is ambiguous and applies equally to either view is no evidence of an assent. And so this is where we've spoken to the conduct. Sorry, I'm just glancing.
I see, just really for our own information, that the current equivalent of Section 3 of the Bahamian Administration of Estates Act in England seems to be Section 1 of the Administration of Estates Act 1925, which is in similar terms except that it omits the phrase in subsection 2 about holding the estate as trustee.
Yes, my lord. Pardon me, I should have said that. We addressed that in our submission, actually.
Right.
And we indicate that the English law has gone one way,
Yeah.
and the Bahamian law has gone another way. And it's not just our jurisdiction, we found. Lords, what I'd like to say...
But is the assent required to actually vest the property that has been bequeathed in the will to the person who's entitled to the property? So,
our position is that no, that it vested once the debts of the estate had been satisfied.
So no assent was needed?
Correct.
There are two things. Is this right? That what had been left to Charles Senior and Edison was not just an equitable interest in the house, but it was the house, wasn't it? The full fee simple of the house.
Yes.
And as I understand it, what you're saying is that either immediately under that provision that you've shown us on the death, or at any rate when the debts are cleared off, the Edison held that property as the legal owner of it on trust for the people who are entitled to it under the will.
Yes, my lord.
Yeah.
Assent, I think, I may be completely wrong, but my impression from this is that when it's a matter of, say, somebody's been bequeathed an equitable interest or something, to actually vest that interest in them, you might have to say that's what you're doing. But or here, they would have had to do something to vest the legal title in Charles and Edison, which they never did.
We are saying that based upon what we have read, the beneficiary, in this case Charles and Edison, even without the formal deed, they became legally and equitably, they had a legal and equitable title to the property once the debt's cleared off.
Yes. Where does assent come into it? An assent.
I would hesitate to say that they've got a legal interest prior to the assent. The personal representative holds the property on trust for them. They have a beneficial interest in it. The assent actually transfers to them the legal interest, and you then go off to the registry of deeds and you register your assent.
Yes.
And
that may never have happened.
And that didn't happen.
It doesn't matter for your case. As long as they still had a beneficial interest in the property, then they kept that interest when it was sold.
When it was sold to Denise. So I heard Justice Stevens, and I must say that prior to preparing for this case, I too held that view. I viewed that the assent was the final act, so to speak. But on preparing for this case, I recognize that there is sort of a midpoint when there is a deed, well, the act of assent can be implied. And what I would add to this discussion, and this is kind of, all of these arguments, as your lordships would have already indicated, really came about as a response to what we say are new arguments with respect to Section 3 and its impact. And we also say that it's somewhat unfortunate because this particular argument actually also has a cultural aspect to it. It's quite common in the Bahamas that when executors are granted probate, that they think that's it, and off they go. It's very common that they don't do anything else. And so years later, after everybody is dead, beneficiaries are trying to get papers for whatever they may have inherited. But you don't have the benefit of that evidence because this was never put below, so it was never argued below, so you don't have the benefit of any judge putting that in writing. But this is somewhat of a cultural issue in the Bahamas with respect to probate. But it is not uncommon, my lords, for what it's worth from this place, to say that a deed of assent doesn't issue. And my lords, just to say, of course, that we've hit this before, but of course, even the attorney recognized that Charles had an interest to the point where they distributed proceeds of sale, albeit improperly, because they shouldn't have sold, but even if they sold, it should have gone in trust to the estate. But nonetheless, they purported to distribute in accordance with his existing interests in the property. And it was the Attenborough case that I took you to incorrectly that is the leading case on implied assent. And it's a case where the beneficiaries inherited various items. There were some items left over, including a silver plate. And one of the executors took that plate and pawned it, and then he subsequently died. And the remaining executor of the estate sought to regain that plate for the benefit of the remaining beneficiaries. And in that case, the House of Lords found that everything having been done on behalf of the estate, all the debts having been paid, that silver plate became, that the beneficiaries became entitled to it, and therefore the remaining executor did not have the right to sell it. He could not pass title, and it was passed back to the estate. And just to take you to the extract of that case, that can be found, I took you there already, at page 1665. My Lord, of course, I should also say, as we are looking for that page, I should not overlook the decision that your lordships would have passed to us, which makes exactly the same point about the executor becoming a trustee, or the beneficiary's trustee, once the debts have been cleared off. And we say that, of course, that is still good law. It's an old case. I think it was a 1920-something case. Do you know the name of it? But we believe that that case supports the position that we've been making today. That is the In Re Ponder case, Ponder v. Ponder. And so this is a 1920 case, pardon me.
So that was before Section 1 of the Administration of Justice Act, Administration of Estate Act 1925.
Yes. What did it cite? Did it cite a case to a statute? Let's see. Pardon me, I'm glancing to see if it. At a glance, my lords, and I mean a very quick glance, it doesn't seem to me that it cited any particular statute. It does say at page 62 there of second paragraph that In re Smith and In re Adams showed that when the estate has been cleared and the residue ascertained, an executor or an administrator holds the residue in trust for an infant legatee within the meaning of Section 43 of the Conveyancing Act 1881. Now, I don't know from reading that at a glance if that Section 3 is an infant within the infant legatee within the meaning of that act, or if it's speaking to the principle of law that we're looking at. But it does cite Section 3 of the Conveyancing Act 1881. And on the footing that he has become a trustee, is entitled to apply the income for the infant's maintenance as provided for by that section. So perhaps the foundation of this lies in Section 43 of the Conveyancing Act 1881.
No, that provision is to do with the powers of trustees holding property in trust for an infant. So it only applies because of a broader principle that which I think one sees in the previous paragraph on page 62 of the report. The proposition for which Eaton and Daines is said to be authority. That when an estate's been wound up and the trust property is in the hands of an executor freed from the administration of the estate, the office is then changed to that of a trustee. So it's because he's a trustee that Section 43 of the Conveyancing Act applies, whereas an infant. Yeah.
Lord, is in the Attenborough case. At page, just trying to find it exactly. You have the, trying to find exactly in the print. Which part is that? Sorry, I thought you were doing something else. In other words, I had started to take you to this earlier, as Justice Lagat would have indicated to me. I jumped all over the place, but it was relevant here, which is that, and I just repeat here at page 1665, my lords, if this is so, this appeal must be disposed of on the footing that, in point of fact, the executors assented at a very early date to the dispositions of the will taking effect. It follows that under these dispositions, the residuary estate, including the chattels in question, became vested in the trustees as trustees. And then over the page, above the line, it says, upon no hypothesis did the appellants get a legal title to the property in the plate. When A.A. Solomon handed over these articles of silver to Messrs. Attenborough, he had no property to pass as executor, and they got no contractual rights to which could prevail against the trustees. The latter were the true owners, and they are now in a position to maintain an action. And then... Well,
I must say, I don't find it easy to see how all this fits together. We've got the proposition from the Section 3.1 of the Administration of Estates Act that the person is a the executor is a trustee from the outset. We've got the proposition from Ponder that, and other cases, that once the debts have been cleared off, at that point the administrator or executor becomes a trustee. And we've got the proposition from the Viscount Haldane that once there's been an assent, the executor becomes a trustee. I don't know which of those three is the correct analysis, or whether they all fit together somehow.
Yeah.
I'm afraid we don't have any experts. Well, I mean, we don't know, not on this side anyway of the court.
Yeah.
So we're looking to you to tell us the answers to these questions.
That is, in fairness to you, we're conscious that we presented you with the Ponder case for the first time this morning.
Yeah.
Mr. Rowe has asked us for a week to put in submissions about this topic, and if you would like to wait and see what he has to say and then put in your own response, say within the week after that, that might be a reasonable way.
We most certainly will
forward.
accept that offer. That proposal.
Somewhat minded to ask whether I might bid for a week and a couple of extra days, my lord, but I'm in your hands.
Yes, well,
Would a week on Monday suffice?
yes. So well, I don't think there's any problem about that, Mr. Rowe, and we would give you another week.
Thank you so much. Thank you, Mama. I don't want to. What was the one I wanted to look at? 17. I would have just brushed on the point, my lord, that the other way in which the executor becomes a trustee is upon a specific device under the will. And the case that we rely on for that would have been Bryan and, I say Rios, 1960 case, New South Wales. We refer to it as paragraph 79 of our submissions, which is at 1415. The case itself is in volume 1 at 1704. Excuse me. Do you have the...
How does a personal representative become a trustee once they've assented to the transfer of the property? I mean, I have some difficulty about that concept, that it is only when they assent. I mean, what else can they do? They've assented to, they've got no more interest in it.
The implied assent, if they haven't, it's only when there is an implied assent, because of course, if they've actually assented, like you say, they fully divested themselves of the asset or of the realty. But if they haven't, then they remain, they're still standing over it as a personal representative and trustee until such time as they actually issue the formal assent, the deed of assent. At page 399 of that ruling of the Bryan and Reese decision, which is at page 1704, and it's the second full paragraph beginning, of course. Of course, in the case of a specific legacy or a general bequest, the beneficiary takes under the will. However, he does not take absolutely and immediately, because the subject matter of the legacy may be required by the executor for purposes of administration, particularly for the payment of the testator's debts. The effect of the assent of an executor to a legacy is to give the beneficiary a complete title to the asset. And I emphasize, an assent is a mere indication that the property is not required for administration purposes and therefore may pass as the will directs. And that is a quote from Williams on assent. And then it goes on, quote, the bequest of a legacy, whether it be general or specific, transfers only inchoate property to the legatee. To render it complete and perfect, the assent of the executor is requisite. Tola law of executors. Thus, in the case of executors, it would indeed be difficult to describe their assent to a legacy as an assignment of the subject matter of the legacy to the legatee. And then I emphasize this. The assent causes the property to vest in the legatee, but it is not the instrument of the vesting. So, by that, we understand that the instrument of the vesting is the will itself once the debts have been cleared off. Pardon me, Lord. So, relying on those principles, we say that the true position is that when Edison conveyed the property to the appellant, he didn't have any property left to pass on as executor. So, and we of course say that the respondents are therefore entitled to recover the property. We've touched on this briefly, Edison's power to sell. I've already indicated that we do maintain that they can only sell under two provisions of Section 22 of the Administration of Estate Acts. The Act is found at page 1498 of Volume 1. And the Act provides that the two purposes are for distribution, for paying debts, but also for distributing the estate among persons entitled thereto. We say that when Edison sold the asset out of the Pearl Moxey estate, that he was not, that we agree with Justice Winder, that he was not actually pursuing either of those two rights or those two exercises. The debts we've already indicated, there would have been no debts left to pay. And with respect to distribution of the estate, there was no need at that point in time to distribute after 20
Well, you say it had, your argument is it had been distributed, is it? It had been vested in the beneficiaries under the will?
Yes. If we consider that a distribution, then yes. It was already vested.
So what was he doing? He was selling his half share, was he? Is that how we should look at it?
He could only, well, he purported to sell our clients.
I know, but the effect of the transaction was that he did sell his half share, was it?
Yes, definitely. And so we also agree with Justice Winder's finding in that regard. I think, my Lords, of course we commend the entire written submissions to you, and I'm just, again, we've already touched upon the fact that he failed to ascertain the wishes, and so therefore, even under Section 22, he hasn't satisfied the requirements. We've touched upon the fact that it's not a good faith transaction. So, my Lords, unless I can, as I said, I commend the entirety of the submissions to you, but unless I can be of further assistance, I do not say more.
There is a power of attorney given.
Yes.
Is there a document in our bundles that, or was it just a description?
And I know that I certainly asked for it and tried to, I don't know what happened to the power of attorney. I do know, what I can say, my Lords, is that the power of attorney, we became aware of that document on the cross-examination of either Barnes or Francis, Bridget Francis, and Butler Francis. And I believe that document may have formed a part of the probate registry application. And I think, if I recall, we actually had to stand down to requisition the probate registry's file in order to see the document. And I have a feeling that's why it never made it into the formal evidence, because it was walked over to the court for us to have access to the document. The original documents were a part of the court's file, court's probate file.
Okay.
Yes.
My lords, if you wish, it came up as we were preparing the submissions that I was chasing that, but if you wish, and I don't know if it's possible, but if it's possible, we could certainly make an effort to say to them that we need it as a part of, to submit to this court, and I'm sure they would facilitate, I think they would facilitate it.
Well, we don't really need it.
I don't think we need it. No, I don't think we really require it, thank you.
Okay, thank you, my lords.
Mr. Devine-Smith, do you follow?
I'm fine, Lord. I have nothing else to add. I stand with what my senior has said.
Thank you. Thank you. Mr. Rowe?
Thank you, my Lord. There's maybe something of which the board's already aware, of course, but so far as it helps with the question about the power of attorney, quite a lot of it was read out in the course of the cross-examination. You can see that at 1455 and following.
Thank you very much indeed. Thank you.
That at least gives you some of the content of it, if not the document itself, if you're interested in it.
Yeah.
My Lord, I've only got a few points to make by way of reply, and in the light of our discussion earlier about written submissions, I hope your Lordships will forgive me if I don't extemporise a complete answer on the question of
Yes.
the precise relationship between assent and equitable interests, and etc., etc. But,
Yes.
my Lord, the starting point is, I'm going to go back first of all to the limitation question, is this. My learned friend fairly climbed down from the contention that the issue of limitation was raised judicata, but went on to say that the respondents don't accept that concealment wasn't raised at the trial. And that's important in my submission for the reason that we give in our written case, where we explain that, as we submit, if it's once accepted that an action is time-barred but for the operation of the sections about concealment, then the burden to persuade the court that concealment is the way out lies on the party invoking those provisions. And in our respectful submission, it's quite plain that at trial there was no attempt made by the respondents in relation to limitation to do more than simply assert that the thing was the thing was raised judicata, rather, and so that it couldn't.
Well, there was. It may not have been pertinent, but there seems to have been quite a lot of debate about what Barbara said about the sisters getting the property and so forth.
Well, there was
it was explored in evidence. Presumably, there was an argument that they'd been deliberately put off the scent. I mean, that was the gist of it.
I agree that it was raised in evidence, and I think my learned friend did use that expression. But it's important for present purposes, in my respectful submission, my Lord, to see first of all what was actually said by way of submissions about the point. We can pick it up from page 272, which are the written closing submissions. There were no oral closing submissions in this case. And there the respondents say that there are three issues for determination in paragraph 4, bottom of page 272. Firstly, whether Edwin Moxey was as executor was entitled to sell the property. Secondly, whether Denise Barnes was a bona fide purchaser for value. One should probably add for value without notice being the perhaps critical part of that. And then thirdly, whether Pearl and Charles Moxey, the plaintiffs, are still entitled to a legal interest in the property. Those were how the issues were identified. None of those issues were have the respondents made out a case under the provisions on concealment. And then when we look at the substance of what was said about limitation, we can see again that what was relied upon was simply the supposed res judicata, and that's at 324.
272 is the claim.
And our learned friends there simply say, as you see, paragraph 127 to 130, that it's too late.
Yeah, well, the judge didn't accept that, but he went on and decided the point.
Yes, he did, but that might...
I don't think you argued in the Court of Appeal that he wasn't permitted to decide the point, and therefore his, everything, the whole issue was not available anyway. You sort of said that he was wrong.
My Lord, yes, but one of the reasons he was wrong was because no case had been advanced. But can I turn then to what the judge did do? And because I appreciate I can't just rest on that submission, and your Lordship's about to say, well, let's look at what the judge actually decided and what the material in the case was. I think I've sufficiently made the point that the judge's way of analysing matters by reference to the lie about which evidence was given by Barbara, whenever it was, 2003 or 2006, was the judge's way of dealing with it was unsatisfactory and indeed insupportable in our respectful submission for the reasons that were identified in argument, that it just doesn't, that can't be linked in any way to the appellant in my submission. My Lord, but that of course doesn't necessarily conclude matters, because as was discussed during my opening of the appeal and subsequently, it might be possible to look in the material and say, particularly in the light of where the law's been clarified since, say, well, yes, but there was nevertheless material which makes the judge's decision right. But my learned friend rightly and fairly and squarely identified that the respondents need to answer the challenge that's laid down in the Potter case to identify a series of hurdles to get over, the first of which is the fact that they needed to know in order to pursue the claim. And our learned friends say, well, that fact was the fact that the father had a half interest in the property. That is, to use the language that was used in the Potter case by your Lordship, that was the fact that was kept secret on the respondent's case, that being the meaning of concealment. The trouble with that submission, my Lord, is that the evidence, and I'll seek to make this good in a moment, the evidence was that until the alleged lie, they did know that the father had an interest in the property. And that's why they needed to rely upon the events in 2003 or 2006 in order to get home under concealment. Because you can't conceal from somebody something that they already know. What was being said was not, well, we never knew anything about our father having any interest, and moreover, we were expressly told that he didn't. If that were the case, one could perhaps see, well, the moreover doesn't matter, even if you take the moreover away. The fact is that they were in ignorance of his interest, and therefore, at the time of the transaction in 2003, you might characterise not expressly drawing it to their attention as concealment, arguably. And of course, they'd rely upon Potter to the effect that there doesn't need to be a positive duty to disclose. But my Lord, that's not what was being said in the case, and that argument just doesn't work on the evidence in our respectful submission. And can I just take your Lordship to the references briefly to show why that's the case? My Lord, if one starts in the witness statement of Pearl Moxey, that's the relevant part is at page 600, and I'll start again, 760. And she says, I'm going to pick it up from here if I may. She says, you'll recall this at paragraph 17, this is about the incident, what she describes as discovery of ownership. She says that it was at that time, she says 2005, 2006, that my mother called Aunt Barbara so that we could move back into the house, because she had nowhere to go with my brother and I. My mother was informed by our Aunt Barbara that the house had been left to the sisters. And we believed her and had no reason to think she was lying to us. Well, of course, the premise of ringing up and saying, well, we want to move back into the house, is that they had some basis for doing so, namely that it was their father's house. And I showed your Lordships earlier, I think, that this was explored to some extent in cross-examination. And just to go back to it briefly, if I may, the reference is, I think, 1036. In the middle of that page, line 11, we knew the house was his mother's own, that he lived in the house after she died, and that she left it to him. We never knew that Uncle Eddie had interest in the house until I found the documents in 2014. So how did you know she left the house to him? We assumed she left the house to him, that's to say to their father, because it was her house and he lived there from when I was a baby. So you assume the house was your father's house? Yes, ma'am. So when you refer to my daddy's house, that's based on your assumption that his house belonged to your daddy. So actually at that stage, her belief is that the house, the whole thing, belongs to Charles Sr. And there's similar evidence from some of the other witnesses. If one goes to 747, now we're in the witness statement of Yvette Gooding, or Camille Fleuribond. That's to say the respondent's mother. She says on page 747, paragraph 15, that there was a conversation when she was pregnant with Charles Jr. 4 lines up from the bottom.
Who's Porky, sorry?
Porky is that's the nickname for Charles Sr.
Right.
He told me that the house was left to him and his brother, Eddie. I remember that clear, because that morning he must have caught the number or something. He was counting the money to the table.
So this is the mother of the
respondents.
Of the respondents.
Yeah.
Yeah. Okay.
Saying that she's been told by Charles Sr. that the house had been left to him and his brother. And that's what...
Must have caught the number. Does that mean he won a lottery or something like that?
Yes.
Yeah.
Probably, yes.
It's not.
Yeah. And then, of course, she goes on then to give evidence, the evidence we looked at earlier, I think, about the conversation later on, when it's told actually no, the property was left after he's died. The property's nobody left to the sisters. And the other reference I wanted to show your lordships in that context is 840. This is in the evidence of Charles Jr., the other respondent, in the witness statement. Paragraph 29, he's talking here about just after his father's funeral. And he says at 29, I told her, that's to say Barbara Barnes, I told her this is my daddy's house. Aunt Barb told me to pack up my stuff, and I asked her why and kept saying that this was my daddy's house. She told me that I can't pay any bills, I have to go by mummy. And later on at 32, he gives evidence about being given the cheque, which is after the property's been sold. Aunt Barb called me and Pearl, told us he had something for us. 841 now. We went by her, she handed us a manager's cheque from the bank for $3,000 each. She told us that she was waiting for us to turn 18 to give it to us, and this was all the money that Daddy had left us after she paid all Daddy's bills. We believed her because we never knew Aunt Barb to be lying to us. We never knew her that kind of person. She sat us down and asked us how we were doing. This was at her house, and she then told us.
So what page number is that, sorry?
Sorry, it's page 3, forgive me, page 841.
41, yeah.
Last line of that page, I asked Aunt Barb, so what's going to happen to the house? And she said to us, but I remember that. Sorry, I've skipped over. What's going to happen to the house? And she was like to be, and then there's a blank. I can't remember what the exact words were she said to us, but I remember that after she said it, it caused us to believe that Daddy's house did not belong to us. We believed her. Well, the point I take respectfully and suggest that has to be taken from this part of the evidence is that the case doesn't work on the basis of saying, well, never mind that the judge got it wrong about active concealment. because there was no positive disclosure, because the evidence was that until the alleged active concealment in 2003/2006, they believed the property was their father's, or their father had an interest in it. So that case doesn't work in my submission. It's why the respondents had to rely upon saying, well, whatever we might have previously thought, we were put off the scent, to adopt Lord Leggett's phrase, by what we were told in 2003/2006. But if the board accepts that the judge's finding that was something that was done by, or somehow deemed to be done by the appellant, if the board accepts that the judge's finding that effect isn't supportable, then the whole thing falls away, and there is no case based upon concealment, in my respectful submission. So if we're right about that, my lord, then the case succeeds on limitation, unless there is some basis for saying that limitation doesn't come into it at all, by virtue of the operation of the law in relation to the estate. And well, can I just touch briefly on that, notwithstanding the fact that I'm gratefully and respectfully going to take up your lordship's invitation to put some thoughts in writing in due course. Or I should say we are going to do that. The judge's own finding, of course, about the estate was explicitly that it had not been wound up, to use the term which is used in the Ponder case. He says that explicitly in his judgment. Just remind myself of the passage which I flagged but have momentarily lost.
Well, he's plainly wrong, isn't he?
It's page, if you start at the bottom of page 369, this is in the judgment, the following are noteworthy. A, the property had remained in the estate of Pearl L untouched for 20 years. And that probably should be following 20 years following her death. However, steps are taken to dispose of it within days of the death of Charles Sr. So the judge's own finding is to the effect that, as we see, that property had remained in the estate of Pearl L. In other words, there's no basis for any finding on the evidence to say that actually the estate had been in any sense wound up. And if one goes back to what was...
The thing is, there's a sort of contradiction in paragraph 17 of his judgment. Well, when he refers to the power of attorney, because that was to secure the sale of the property out of the estate of Charles Moxey.
Yes,
and nobody seems to have, well, he didn't seem to confront how that stood with selling it out of the estate of Pearl.
No, well, that power of attorney didn't in the end didn't really go anywhere. I mean, it was used extensively, I think, by our learned friends as, I think, in support of a suggestion that they all knew that Charles had an interest in the property, but it didn't.
If you give a power of attorney to sell the property out of the estate of Charles Moxey, then you'd assume that the person who gave that power of attorney thought that the property belonged to Charles Moxey.
Well, that was...
yes, that subsequently changes his mind. And
was there an attempt to get administration of the estate of Charles Moxey, which didn't succeed?
As I understand it, there was an I think yes. There was an application.
Yes.
It wasn't proceeded with.
So, I mean, the inference is that they thought it belonged to Charles Moxey. They didn't manage to get power to sell it out of his estate, and so they decided to sell it out of the estate as though it hadn't gone to him after all.
Well, my lord, that may or may not be the right inference, but it doesn't matter for present purposes in our submission, because
that's why I wanted to see the actual power of attorney. But anyway, be that as it may. Yeah. I mean, we have got sufficient findings there from the judge to deal with that.
Well, the fundamental point, my lord, is that as regards what matters in my submission for these purposes is if the submission on behalf of the respondents is to get off the ground, that is to say the submission that none of this matters because actually there was a pre-existing equitable interest in the property that that the estate of Charles Senior had at all times, if that submission is to get off the ground, it's got to overcome the fact that the judgment itself speaks explicitly in terms of the estate not having been distributed and the property remaining in the estate of Pearl L. And if one looks at what's said, and this is all obviously subject to refinement in the course of some written submissions, but if one looks at what's said, for example, in the Ponder case, the language is there about the estate having been wound up. It's at that point, once the estate has been wound up, that the executor ceases to be an executor and becomes simply a trustee. But, my Lord, there's no sufficient basis in my submission in the present case for thinking that the estate had been wound up. I've shown you just now how the judge looked at the matter. The property remained in the estate of Pearl L, as his explicit words. And although it's been a long period, obviously, since the death, with nothing done by way of seeking to vest the property formally, whatever exactly that means in law or equity in Charles Senior. What one can't, in my submission, simply take from that, well, in practice, the estate had been wound up, so there was nothing further to do. I mean, my learned friend asserts, well, there were no debts. There was no evidence either way as to whether there were any debts. And the only answer the learned friend can have to that is to say, well, limitation would have prevented any debts of Pearl Senior being enforced. But I mean, even that we don't know, because it depends on the nature of the debt. Now,
if there had been any debts, they would have had to be paid out of the proceeds of sale, wouldn't they?
Yes, they should have been, if there were any. Yes, yeah. But
look at it another way, and that is what took place in 2003, 20 years later, could hardly really be the administration of the estate, because you sell the property in undervalue, you don't advertise it for sale, you don't get any valuation of it apart from one subsequently. You give the money not to the estate of Charles Senior, but you give it to Barbara. That can hardly be the administration of the estate. All those are grossly inappropriate.
Well, Muller, that, in my respectful submission, is more of a criticism of the way the estate was being administered than a statement that the estate wasn't being administered. I mean, what actually happened was that the property was sold. There was. I mean, I'm stuck. I think with the judge's finding that it was an undervalue, although there was actually very little evidence about that either way. Everything was hung on the one affidavit that was sworn by the appellant. But be that as it may, the property was sold, and they didn't.
Well, she certainly thought she was getting a bargain.
Well, Edison didn't make off with all of the money. He through Barbara, caused it to be distributed, and indeed went so far as I don't think we've looked at it yet, but your lordships will be familiar with it, I expect, will have read about it. Went so far as to draw up a schedule, which was cross-examined on in some detail as to exactly where all the money went. Now, one can criticise that and say that's not right, but for the present, the question for present purposes is, can it be said on the part of the respondents that by this point the estate had been wound up, to use the terminology in Ponder, so that the position that pertains as of the moment of the death no longer pertains. So it's no longer a case of the executor having all of the legal and equitable interests in the property, and indeed there being no distinction between the two. See Viscount Haldane's statement in the case that we looked at from Queensland. It's something different, and in my submission that we don't get to that. We don't get to that point on the evidence. The whole case was rightly dealt with on the basis that the property remained, as the judge said, in the estate, and that being so, there is we submit no mileage in the suggestion that there was at that point an existing equitable interest. Well, that's obviously has to be subject to the various possible qualifications to that, some of which I'll seek to deal with in writing. But by way of a broad indication on my feet, I think Lord Stevens mentioned at one point, what about a constructive trust? And does that have an effect on matters? I think the answer to that is that it depends what sort of constructive trust we're talking about.
Yeah.
If it's a Class 2 constructive trust, to use Lord Justice Millett's terminology in the Paragon Finance case, then Section 33(1)(b), which is Section 21 of the English legislation, doesn't bite. In other words, the claim to recover trust property. It's got to be, as it were, a real trust as opposed to a constructive trust. So I would submit
what seems clear from Williams when you get to look at this and do your submission. I think it's a case called Williams and Nigeria or something like that, which I briefly looked at, is that it doesn't count as a constructive, as a trust in the relevant sense, if it's a claim for either receiving trust property, knowing receipt, or dishonestly assisting in a. That's clear. I wasn't sure what the position is. If it's not a sort of orthodox trust, but it's simply that because you bought property, but you're not a bona fide purchaser for value without notice, you don't take clear of the equitable interest. I'm not quite clear which side of the line that trust falls on.
No.
And on a quick reading, it wasn't really. I couldn't see that being addressed. So that just highlight what seems to me a point that. Be helpful to know the answer to.
Yes, well, I'll seek to deal with that, my lord. But I says, well, it may well be what it comes to is that there's not much mileage in asking whether it was a constructive trust. So really, it comes down to analysing properly what if any the interest consists of. I say what if any. There is clearly there's an interest in a broad sense that you have a right to hold the executor to the executor's duties. But what's the nature of the interest? Lord, then there's the question. Then there's the statutory point. Does Section 3 of the Act, the Administration of Estates Act, of the Bahamas, make any difference? And as your lordships, I think, mentioned in the course of my learned friends' submissions, we in our case have tracked down a couple of cases from across the Irish Sea. One in Ireland saying that the state doesn't have the effect of vesting an immediate interest on trust, and one in Northern Ireland saying the contrary. My lord, those two, just by way of brief reference, those two cases are the first one is at 2335 in the authorities in the record. May I just take your lordships to it briefly?
I mean, if the position is that the estate has some debts to pay off, so it's hard to see how immediately on the appointment of the executor they could become a trustee of a particular piece of property for the beneficiaries.
Yes.
If they don't yet know that there's enough assets for them to be given that.
The estate might be insolvent, might be completely underwater.
Yeah. So they couldn't become a trustee for a particular item of property, could they? That's why I would.
Or of the residue, which is why, in my submission, in principle, any attempt to distinguish between specific devises and the residue doesn't work, because in either case, as of the moment of the appointment of the executor, or the moment of the death, one just doesn't know what the property might or might not be required for.
But that's why the cases seem to say that once the debts have been paid off, at that point, either it does or it can. At least be held on trust for the beneficiaries under the will. Well, if not vest in them.
Query exactly what that means, my lord. But that's
Yes, obviously, if there are Bahamian authorities on the effect of Section 3, subsection 2, that would be very helpful to us to know about.
Yeah. And there might have been some English authorities that it's quite hard to find now because it was superseded the legislation under which, so there wouldn't be many books that would bother to include them.
No.
You have to go back to an old version.
No.
Yes, Lincoln's in library.
I can certainly sense a
Victorian textbooks on this.
Looming, my lord.
I'm afraid Westlaw didn't help me this afternoon. So,
Nor did Lexus.
yeah.
Not yet, but we'll see. But my lord,
You could be a trustee and a personal representative at the same time, with the duties of the personal representative taking priority for the discharge of debts and so on, and then a trustee of remaining a trustee. The two duties could exist together, and the conflict, if there was a conflict, could be resolved in favour of administering the estate.
I suppose, my lord, that's with respect, that's right. But I'm querying whether that necessarily answers the question in our case, which is really whether there is an identifiable separate piece of property at any point, at any relevant moment.
This is a bequest. The only thing is a bequest of this property to two people as tenants in common, and that's all.
Yes, Pearl's estate doesn't appear to have had any debts.
Yeah.
Well, it doesn't appear. It doesn't. I agree. It doesn't appear. It doesn't appear not to have had. We just don't know. There's a blank in the evidence about that. Well, what I was going to get, I was showing you very briefly, and as it were provisionally, but the Trentdale case that we cite. This was a case where the reason it was relevant to ask what the nature of the interest was because a creditor was seeking to register a charge, I think, over the interest of the defendant, and if the interest of the defendant was an interest in property under a trust, then that was a valid registration, and if it wasn't, then it wasn't.
The defendant was the beneficiary of the will, was it?
The defendant was both the personal representative and the beneficiary.
Right.
Now, the Northern Irish case was?
The Northern Irish case, my lord, is the... I put my note.
This is Mr. Justice Gibson, I think.
That's right, yes, Re Kavanagh.
And page number, I'm sorry?
That's at 1842. So we see, if we look at paragraph 15 of the Trentdale case, 15.2, the defendant argues the claim cannot succeed against her in a personal capacity as a beneficiary, as she has no proprietary interest in the land, whether in law or in equity, having made no assent to herself as sole beneficiary. And the learned judge then goes on later to cite the relevant provision, which is at paragraph 23 in the judgment.
24?
Yeah. Sorry, did I say 20? Right. 24, yeah. And the conclusion at 36, taking into consideration the comments made in Gleeson and Dolan, which are two other cases that have been looked at, the court is of the opinion the defendant does not enjoy any interest in her mother's estate in her capacity as sole beneficiary in the absence of an assent.
So what's the effect of that section on this view?
Well, on this view, the effect is that as 38, as all interest in the land vests as it stands in the defendant in her capacity as the legal personal representative of her mother's estate. So by analogy, in our case, all interest in the land vested in Edison.
I know, but what's the meaning of the provision if it doesn't mean that you're a trust, that the person is a trustee?
I didn't myself find that the positive, the answer to that positive question as opposed to the negative question, does it mean what the plaintiff in that case wanted it to mean? I didn't find that in the judgment, but in our submission, what it must refer to is that where there is property which is already subject to a trust, then the executor holds that property on that trust, rather than creating a trust out of nowhere.
Well, both this case and the Northern Irish one seem to turn on the wording of a particular legislation.
Yes. But I think in those two cases the wording was the same as in our case.
Mm-hmm.
It's very hard to read it that way. It just says that she'll hold the estate as trustees for the persons by law entitled to it. It doesn't say such part of the estate as is trust property for the people who are the beneficiaries of that property.
My Lord, no, but the real question is, of course, what's meant by persons by law entitled thereto?
Yes.
Does the legislature by that mean those people who are listed in the will or under the rules of intestacy as the people to whom the property will pass? And in my submission, it doesn't. That's not what it means. Indeed, it will be contradicting the pre-existing, well-established position that we looked at earlier to describe those interests, as far as their interests, as what people are entitled to.
Yeah.
Because they may have no entitlement at all, because for the reason that the estate is insolvent.
Yeah.
So, my Lord, that's for present purposes what we say about that, and we note what was said in the Northern Irish case, but we submit with respect to the learned judge in the Northern Ireland case, the reasoning there is somewhat conclusionary rather than analytical, and simply asserts at the end.
Doesn't he analyse a whole series of cases in the Privy Council and so on?
Well, he analyses the common law position, but then goes on fairly briefly to say, well, that doesn't. It's paraphrasing, but essentially it doesn't matter because of the terms of the statute.
Yeah.
But it's the last bit that I describe, perhaps unfairly, but I describe as rather conclusionary. It does not a great deal of analysis of how one should read the words of the statute in the light of the pre-existing authority. So in that case, you see the conclusion at page 1849. I declare the judgment mortgage is well charged upon the defendant's interest in the property. But, my Lord, that whole aspect is, of course, to be continued. I think the only other thing I wanted to touch on my feet briefly, if I may, is section 22 of the Act, the provision that says a personal representative may sell the whole or any part of the estate of a deceased person. That's the one at 1498. And your Lordships have our submission in our case. We say, first of all, the unspoken premise that section provides the only two circumstances in which the representative may sell property is false.
Why?
Because it doesn't in terms say that the only circumstances are as follows, and because reading the statute as a whole against the backcloth of the established powers of a personal representative, it wouldn't make sense for those to be the only circumstances in which property could be sold. And I offer the example we offer the example in our case of the situation where it's not intended either to. The purpose of the sale is neither to pay debts nor to distribute among the persons entitled to the property, but is some other purpose. We offer the example of simply preserving the value. If for some reason
but that's
property,
to distribute. You distribute more if you preserve the value.
Yes, but that's not the trustee. The personal representative may have no intention of distributing at all at that moment, and indeed the terms of the will may make it clear that distribution isn't to happen at that stage. But if the personal representative conceives a need to sell the property, in the example I've given, for the purposes of preserving its value and converting the property into some other asset class which is not falling in value, then it would be odd if Parliament had by a side wind removed the power to do that on the basis that the only basis upon which you can sell property is to pay debts or distribute the estate among the persons entitled thereto. But that's our submission of law as to that. But we also say in any event it doesn't matter because the evidence was overwhelming in the present case that we respectfully submit that the estate, the property here, was sold for the purpose of distributing the estate among the persons entitled thereto. It may not have been done either on the judge's findings at a fair value or in a correct and regular fashion. because, as we've seen on the evidence, what Barbara did was to, on behalf of Edison, was to sell and then to take the proceeds and do her own distribution of them, which, as a result of what she said was paying off debts of the Charles, resulted in his heirs only getting a relatively small sum. I accept that that's clearly not the way of doing it by the book, which would have been to establish clearly who exactly was representing the estate of Charles and then pay the entire money over to that person and say it's your problem to sort out what to do about his debts. But that's neither here nor there in my submission. For the purposes of deciding whether the power was exercised for one of the statutory powers, if it be right to say that those are the only powers, the only reasons that one can have for selling an estate, if there is no power to do so unless those reasons are present, then we submit that distributing the estate was exactly what was being done.
If, on the judge's analysis, if it was right that there was no power to sell the estate, what was the consequence of that? What did the judge think the result of that was?
The judge
there hadn't been any power to sell the estate.
The judge thought that I think the judge thought that in those circumstances the interest of Charles, which is the premise upon which this whole argument for the respondents rests, there was a pre-existing interest, never moved. But
well, yes, okay, but suppose Charles didn't have an interest already. I mean, suppose that you were right that the executor was just selling the property, but it was a sale that the executor didn't have power to make. Does that mean it wasn't a valid sale at all? It still belongs to the executor? Or does it mean it was voidable?
Well, that's with respect.
I mean, who has the legal title to the property on the judge's finding?
Well, on the legal title to the property on the judge's finding remains with the appellant.
But why? If the power was if it was ultra vires, the sale.
Yes. Well, yes, I see your lordship's point. But that's a point. I think that's a point in my favour, because that means the judge's reasoning doesn't quite work. Yeah. Unless there is some separate equitable interest.
And I'm just thinking aloud, but you might not want to quash set aside the conveyance unless Pearl and Charles Jr. were in a position to reimburse Denise for loss that she would suffer. I mean, it would be an element of unjust enrichment apart from anything else.
Yes.
It may be that the pragmatic solution is to do what the judge did and simply find that the property remains with Denise, but subject to a trust as to 50%.
Yes, that may be right, my lord.
But it's
the simplest analysis is, at any rate, that if the estate had acquired an equitable interest, 50%, then all that was sold was the legal title plus Edison's half share, and it remained subject to the interest, which wasn't extinguished by the sale because Denise was not a bona fide purchaser, so she took subject to that interest.
Well, I agree that seems to have been the judge's analysis. Yes.
Yeah.
So, my lord, that's I think pretty much where I wish to end my submissions and replies, subject to such opportunities I can take in writing to answer further some of the questions that your lordship's questions have given rise to.
Yes. Well, thank you. This has been a learning experience, I think, for all of us. I feel we're being set an examination question.
Well,
could we invite you to provide us with your submissions on the issues arising from the authorities that we gave you this morning? I mean, essentially, this issue as to the effect of Section 3, subsection 2 of the Administration of Estates Act in the light of the relevant authorities. And if you could give us those by the 22nd of April.
Yep.
And can we ask you to file submissions in response by the 30th of April? And once we have those, we'll consider the advice that we will humbly tender to His Majesty.
Sorry, my lords.
Yes.
Mr. Smith is saying to me that there were two questions that you asked, I don't know which ones, that were answered in the ruling of Winder J. If we could have an opportunity to just respond to those two questions by pointing you to the paragraphs in the ruling.
Yes, that's fine.
May it please you, my lords. The first question was in reference to whether or not there was an application for the administration of the estates of Charles Sr.
Yes.
And that is confirmed in the electronic bundle, page 359. At the very top, Justice Winder lays out Barbara Edison commenced an application for the administration of the estates of Charles Sr. Charles Sr.'s interest in the property is listed in the schedule of the real property, notwithstanding the sale to Denise was complete since 8th of May 2003.
Yes.
The sale proceeds in the sum and is listed application unable to proceed as the interested party is not cleared off.
Yeah.
So it's confirmed there. And then the second question related to this debate we keep having about whether or not there were any debts for the estate of Earl L.
Yes.
If you have a look at electronic bundle page 371, that would be paragraph 17 of Justice Winder's ruling. I won't read all of it, but he says at the end of that paragraph there, the power of attorney was to secure the sale of the property out of the estate of Charles Moxey Sr. Several reasons as to the purpose for the sale of the property by Edison emerge in bits and pieces of evidence in trial. These include, and if you jump to C, Attorney Francis Butler says that it was for the payment of the debts of Charles Sr., not Pearl L.
Yeah.
Specifically, she says that I can recall at the time of the debt, there were expenses of the estates of Mr. Charles Moxey. Regard would have been had to the estate and the expenses as well. And so in respect to the sale, our position would have been, with respect to the instruction that Mr. Charles Moxey needed to be paid to those expenses. It reads, medical expenses, as you know, I'm sure you would have been instructed. He would have been terminally ill, and so expenses would have been paid towards those expenses. And so at the very beginning, it says it was specifically for the debts of Charles Sr. and not for the debt of Pearl L. And then finally, electronic bundle 456. This is the Court of Appeal ruling, paragraph 39. Just at the very end, the last sentence, well, the last two sentences. Further, that Attorney Francis Butler never produced any receipts at trial showing payment of the medical bills with respect to the estates of Charles Sr. She notes that what was produced were checks that were drawn, but no canceled checks, receipts, or invoices were ever evidenced at trial. So even though they said that it was for the purposes of medical bills, there was no evidence at the trial.
That's taking the decision for the law to answer your two questions.
Thank you. That's very helpful. The court will now adjourn.